Alright, buckle up, because this isn't just a sentencing. This is a full collision of choices, consequences, and a family's worst day. We're in court with Christopher James, who has already pleaded guilty to first-degree felony intoxication, manslaughter with a vehicle, and that one phrase carries a ton of weight. Intoxication means the court is looking at impaired decision-making. Manslaughter means a life was lost, and with a vehicle often becomes the most chilling part. Because a car isn't just transportation in cases like this, it becomes the weapon. And the judge isn't walking in blind here. She has a pre-sentence report, a probation memorandum, and multiple letters from the victim's family. That's important because sentencing isn't just about what happened. It's also about who the defendant has been, what risk they pose, and what justice looks like after the plea. Here's the tension. The defense is going to argue growth education, faith programs, a new plan, maybe even restitution. The prosecution? They're coming in with fire, asking for the full 50 years, calling this one of the worst intoxication manslaughters they've seen, and pointing to a history that suggests this wasn't a one-time mistake. And wait until you hear the defendant's explanation about how PCP got into his system. Because it's the kind of claim that makes judges instantly question credibility. So let me ask you early. When someone has a long history with substances and repeats the same dangerous behavior, where does second chance end and public safety begin? Stick with this one, because the courtroom is about to decide what accountability looks like when the damage can't be undone.
Good morning. Are you Christopher James? And Mr. James was previously in court, entered a plea of guilty to the first-degree felony offense of intoxication manslaughter with a vehicle. I've received the pre-sentence report and also a supplemental memorandum from probation that includes several letters from the victim's family members. Has everyone had an opportunity to review all of that?
Yes, we have, Your Honor.
Are there any additions or corrections to that pre-sentence report?
No, Your Honor. I just want to make the court aware. Mrs. Addison, the deceased's wife, would have been here today to do victim impact. She had to go to the hospital yesterday. She's able to tune in, I believe, and watch us. The rest of Mr. Addison's family is here, and his mother is going to want to do victim impact at the end of sentencing.
Okay. Thank you, Mr. Nichols.
Notice how the court starts. Pre-sentence report reviewed, probation memo reviewed, victim family letters acknowledged, and even a note that the deceased wife would have been here for victim impact but is in the hospital. That matters because sentencing is not just judge picks a number. This is the court making sure the record is complete so the judge can justify the sentence with facts, history, and impact. Also, this early moment is a reminder, in a case like this, the courtroom is basically split into two realities, the legal process on one side and the emotional aftermath on the other. And when the judge asks, any additions or corrections to the pre-sentence report? That's a big deal. The PSI can influence everything: risk level, substance history, behavior in custody, rehabilitation efforts, and whether the defendant is minimizing responsibility. So what you're about to hear from defense and prosecution isn't just storytelling. It's them fighting over how the judge should interpret the same file. Question for you: should rehabilitation efforts matter more when the crime is tied to addiction, or does the outcome, someone dying, override everything else? Because this hearing is about to test that exact line.
Okay. Thank you, Mr. Nichols. Any witnesses with regard to sentencing?
No additional witnesses, Your Honor.
All right, Mr. Lewis, you may make argument.
Okay. Judge, of course, this was a very tragic situation that has affected a lot of people. The decedent, Mr. Addison, his family, as well as Mr. James and his family. It was a situation where, this was a combination of a long substance abuse history of Mr. James. The assessment that's provided in the PSI here says that there was about a 20-year relationship between Mr. James and different substances over a period of time. we have, the one thing I can say is that once Mr. James went through this situation with this accident, he has been doing everything he can to try to better himself. He has got his high school diploma. He's was baptized and has definitely changed his ways and going to his faith and continuing in that regard. He's also got some different certifications that he was able to receive dealing with OSHA, I think it was Men's University, things of that nature to try to better himself, Judge. Now,
Here comes
there's
the
no
defense strategy. Acknowledge the tragedy. Point to a long substance history, then pivot hard into he's changing. You heard education, baptism, certifications, basically a checklist of rehabilitation. And to be fair, courts do look at that, because sentencing isn't only punishment. It's also about whether someone can be safely released someday and whether they've taken real steps to turn their life around. But listen to the tightrope the lawyer is walking. He admits it's PCP again, admits there's a serious criminal history, and then tries to soften the jail incidents by framing many as inmate conflicts and emphasizing he became a trustee. That's the defense trying to say, yes, he has issues, but he's not the worst version of himself anymore. The problem is, in an intoxication manslaughter case, the court is always asking one brutal question: was this preventable? And the answer is almost always yes, because driving impaired is a choice. So what's more persuasive to you? The change after the tragedy or the pattern before it? Because the prosecution is about to argue that the pattern is the whole story.
It's no secret he does have a long criminal history that even included dealing with PCP, which is the same substance that was involved in this accident, and as well as other serious offenses. I do want to address something as far as I know there's some situations here dealing with the jail instances, and I know how the court proceeds or looks at the situation here dealing with those. Mr. James, if you look at these situations, majority of them did come from situations involving him and other inmates, as far as any type of fight or anything like that, which unfortunately some things he can't avoid. But as far as anything dealing with being disrespectful or anything towards jail employees or things of that nature, there's one situation I think that they were talking about that it wasn't an actual write-up, but it was notated. He has been a trustee over there for a period of time at the jail as well. Now, I do want to point out that, of course, some of those situations that Mr. James was able to do to better himself, of course, could definitely increase his earning potential as far as what he had as far as his job situation. He does have significant family support. His brother is here today in the courtroom, who in any way is there to try to help him, including helping secure employment. My understanding is the plan, once he is able to be released, is for him to be moved to Houston, Harris County area, to be close to his brother, to help him with everything over there. Now PSI did have a recommendation for his different vehicles that support that's available to him through the probation department. What I will say is that everything that has been recommended, he definitely needs and will be better for him. We are not, and ourselves are not asking for a specific number or anything like that. We just want him to be able to, of course, make amends for this situation as much as possible, which could include some of the restitution there. I think is the amount is over $100,000 for his restitution there to the family. Now,
That restitution line, over $100,000, is important, and it's also commonly misunderstood. Restitution is meant to cover financial losses connected to the harm, but it doesn't replace a life, and it doesn't cancel prison time. The defense. Mentioning it is strategic. It signals responsibility and an attempt to repair what can be repaired. But the reality is, restitution in cases like this can become symbolic, because long prison sentences can make it difficult for someone to pay meaningful amounts for years. Also, notice the defense says they aren't asking for a specific number of years. Translation: they're hoping the judge gives leniency without them anchoring the court to a low number that might look outrageous. They're leaning into themes: remorse, self-improvement, family support, future employment plans. That's classic sentencing mitigation. But here's the question. If you were the victim's family, would hearing restitution and future plans feel like accountability? Or like the defendant still gets to imagine a future that the victim lost? Because that exact emotional friction is what the prosecution is.
like I said, he has made a plan to try to better himself. He has a family that supports him. He is doing everything he can. He understands that this was a tragic accident, but one he was definitely responsible for. And what we're asking for as much leniency as possible from the court, for him to be able to move forward with the situation, be able to make amends as much as possible. And I think he did provide a letter to the court as well to kind of speak to that as far as an apology letter that was to the family, his family, the family of the victim, as well as to the court, Judge.
And I've received that.
And so that's what we're asking for today, Judge, is for everything to be considered. We understand this is, you can't bring that person back. He can't just go back to make amends with Mr. Addison, but he wants to try to make as much of amends as he can to society and do better going forward.
Thank you, Mr. Lewis. Mr. Nichols.
Your Honor, I think any consideration to Mr. James's due was given when he got a 50-year cap. I have no hesitation asking the court to exercise the full 50 years. This case is one of the worst intoxication manslaughters. It's on video where he plows into Mr. Addison, who's at a stoplight on a motorcycle, and while trying to get away, runs over him and the motorcycle again. It's horrific, Your Honor. What is also just inconceivable to me is that a man who is on parole for several possessions of phencyclidine, PCP, finds himself behind the wheel on PCP again. And this time it ends in the death of somebody. His criminal history is extensive. It starts with minor drug offenses, then a conviction for aggravated robbery, and then I believe it's 5 drug convictions all at the same time in 2020, for which he was quickly paroled out and on parole when this happened. The fact that he gets to make plans in his mind for a day he's set free, I find rather offensive, and I think the Addison family finds offensive. They lost a son, a brother, a husband. There's nothing we can do in this courtroom makes that better. And sometimes the justice system is a poor substitute for what people lost. I think the best we can do at this point is this man spend 50 years in prison where he cannot hurt anybody else due to his own selfish decisions and continued use of substances. It's in the pre-sentence report. He minimizes his own addiction, his own dependency. He even claimed he did not know how he could have gotten PCP in his system the day this happened, that maybe he touched a bottle and it transferred through his skin. And I find that reprehensible, Your Honor. And that's why I'm asking the court for that full 50 years.
All right, thank you.
The state just laid down the core argument. He already got consideration. His cap is 50 years. Now give him all 50. That tells us something huge. There's a plea agreement structure here that limits the sentence, and the prosecution wants the judge to go to the ceiling. They're emphasizing the video, the attempt to get away, the repeat substance issue, and most damaging, the idea that he was on parole and still ended up in the same nightmare scenario again. But the line that really shifts this from tragic to infuriating is the minimization claim, saying he doesn't know how PCP got in his system. Maybe he touched a bottle and it transferred. Courts take credibility seriously. When someone sounds like they're dodging basic accountability, it can erase sympathy fast, especially when the underlying behavior is already dangerous. So let me ask you, do you think a judge should punish most for the outcome, someone died, or for the repeated choices that made the outcome almost predictable? Because the judge is about to speak and you can already feel she's not buying the mystery PCP angle.
So, Mr. James, a couple of things that Mr. Nichols didn't say that I think are also extremely important is this isn't your first driving while intoxicated. This is your third. And so you didn't learn in 2006. You didn't learn in 2017. 2017, you got your second DWI. You were given probation. It was revoked. I appreciate that you entered a plea of guilty because for myself and for the family, I'm glad we didn't have to see what it looks like this would look like on a video, because it is just horrible. And the fact that you are truly saying that you think you touched something and got PCP when you have had PCP cases over and over and over again, and you're on parole for possession of a controlled substance and you kill someone. It's a nightmare. Sure, go ahead.
This is where the judge turns the spotlight from the lawyers to the defendant, and notice what she targets first. Pattern. This isn't your first. This is your third. That's not just scolding. Legally, it's the judge saying, you had multiple warning shots from the justice system, and you still didn't stop. Then she adds something that matters a lot in court. She appreciates the guilty plea because it spared the family from watching horrific evidence in trial. That's the judge acknowledging that a plea can be a form of accountability. But then boom, the credibility issue returns. The judge directly challenges the PCP explanation because it clashes with a history of repeated PCP-related cases. When your story doesn't match your record, judges usually trust the record. And from a sentencing perspective, minimizing addiction or responsibility often signals risk of reoffending, because real change starts with honest ownership. So here's the hard question. If someone claims they were clean, but the evidence says otherwise, should the court treat that as denial or desperation? Either way, it's not helping him because the judge is now deciding what protects the public.
You know, that night that accident happened, I was been clean. The entire time I was on parole. Okay, I stopped off at a friend's house and gave him some advice about what he was doing. And during that time, I did contact a bottle of his. You know, I was not high at that time at all.
It was in your system.
Yes, ma'am. And you know how I fight for it.
All right. At this time, based on your history, based on the nature of this offense, I'm going to find that you entered your plea of guilty freely and voluntarily. I'm going to find sufficient evidence to find you guilty, and at this time find you guilty of intoxication manslaughter. I'm going to sentence you to a term of 50 years in the institutional division of the Texas Department of Correction. There will be a deadly weapon finding based on the indictment alleges a deadly weapon. You will receive credit on this sentence for any time that you've been in custody that the law gives you the right to receive. I'm going to hand you the trial court certification that shows this was an agreement and I followed it, and so you've waived your right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provided you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Lewis. There's really so many other things I could say about how
This
horrible this.
sentencing moment is loaded with legal consequences beyond 50 years. You heard. The judge finds the plea was freely and voluntarily entered, finds sufficient evidence, and formally adjudicates guilt. Then comes a major add-on, a deadly weapon finding. In plain terms, the court is saying the vehicle, under these circumstances, counts like a deadly weapon in the legal sense, meaning the case is treated with a higher level of seriousness and long-term consequences attached to that finding. Then the judge goes into procedural reality. Credit for time served, the certification that it was an agreement, and that the defendant waived the right to appeal. That's typical when a plea deal is accepted. Once you agree, and the judge follows it, appeals get limited. And finally, the firearm admonishment. Because of the felony judgment, he's told he's ineligible to possess a firearm or ammunition under Texas law, and violating that can create new charges. The judge is essentially warning him, your legal restrictions don't end with prison. Viewer question: do you think the deadly weapon finding is fair in cases where a car is used while intoxicated? Or do you think it should only apply when someone intended harm? Because the law often focuses on danger created, not just intent.
Things I could say about how horrible this is, and rarely am I out of words, but I really don't have the words to say what a tragic circumstances based on your behavior this led to. Y'all can have a seat at council table for the victim impact statement, and we'll go off the record. Do you want me to leave it on for the other family member to hear?
I think that would.
If the family member's okay, that's given the statement, then I'll leave it
Mrs.
on.
Addison, I mean, yeah.
If she is not comfortable, then I'll turn it off.
I'll add. Yes, Sharon, she asked that we leave it on, so Mrs. Monica Addison, your wife, and the deceased can watch.
I don't know that they'll be able to hear her unless y'all move a little closer, but if you're fine where you are, that's fine too. Just,
Okay.
okay.
You're right.
First, I give you honor to God, to the judge and everybody in this courtroom. I stand representing my family, Monica's absence and some of my grandbaby's absence because of college and the one that's here. My daughter, my husband, and my nephew. We have had a tremendous loss. I had someone that carelessly drove a vehicle and just took my baby life. Praise God instantly, because I couldn't stand to see him suffer. But after vacation, enjoying him that same day, speaking to him 3 times before he left. And then a phone call come. We had a beautiful day talking 3 times that day. And a phone call come. I missed the call in Monica telling me he's in the hospital. I get there, my baby is dead. My firstborn, very close family. We did our anniversary dinner together, his wife and I. We had a day separation anniversary. We had lunches together for our anniversaries, backyard picnics, birthday celebrations, our grandbabies, his grandbabies. Finally get to be adults, praise God. They're getting ready to enter college. My son is in his happiest moment. Everything he wanted to do. He had his motorcycle, his car, his house, take where his kids going. Like everything was just in order. And bam, it's just taken away in an instant. Behind someone who got behind the wheel, not able to drive. And I heard drug my baby. Till this day, 3 years, I can't pass that way. I can't cross that intersection, not even far from my church, closest to me to get home. I can't make myself drive that way. And I wake up out of my sleep crying. That's crazy. Because of a death taken too soon, behind something like drinking or drugs. Why? I can't communicate with anyone in my family because everybody's bedridden. I'm a baby girl. I have nobody but Jesus to go to understand my hurt. I don't want to disturb my family. They're sick. And to know that I'm standing here 3 years later You should have been come to court for that. I've been hurting and crying, standing for my family, holding myself together. If you all could see the ripples in my heart behind my losses, that I try to stay tall for my family, for my grandbabies and my daughter, my husband. It's hard. No church can even help me because it's hard. Nobody understands my pain but Jesus. And I think whatever they give you today, you well deserve. I don't wish you no bad luck in there, but you're going to once again remember not only the hurt you caused me, but you're going to relive the life that you have taken because you're going to see hard times. It's not going to be.
What we just witnessed is the full sentencing arc of an intoxication manslaughter case where the court had to weigh two competing realities. The defense presented rehabilitation, education, faith, programs, family support, and the claim that he wants to make amends. But the prosecution, and ultimately the judge, anchored on the pattern, repeated DWIs, repeated substance history tied to PCP, parole status, and a version of events that sounded like minimization rather than ownership. The judge emphasized credibility, accountability, and public safety, and she delivered the maximum allowed under the agreement: 50 years in the Texas Department of Correction, with a deadly weapon finding, plus formal warnings about the long term legal consequences that follow a felony conviction. And then came the victim impact statement, where the legal language disappears and the human cost fills the room. That's the part people never move on from, and it's why these cases hit so hard. The sentence closes a courtroom chapter, but it doesn't restore what was taken. Now I want to hear from you. Was 50 years the right call here, or should rehabilitation have weighed more? If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.